So, good morning to all of you. It is really for me a honor and a pleasure to chair this first session devoted to the role of international courts in addressing climate change. There are many reasons why I am so happy to be here. First of all, because this is an event organized by the Institute for International Legal Studies of Italian National Research Council, and I used to direct the Neapolitan branch of this institute for many years. So it is a pleasure to see again many of the researchers and also administrative personnel collaborating, working for this institute. The second reason is that Gianfranco and the other organizers gave us the privilege of involving the International Association of the Law of the Sea, which is one of the institutions mentioned. This institution is trying to open its activities connected to the law of the sea all over the world. And yes, in my capacity of president of this association, we really hope that this activity will also, in a certain way, go on in organizing events like the present one. And may I add also that it is a very fruitful and nice occasion to have together many colleagues and friends. Some of them I have not seen for many years, so it is really a pleasure to be once again with them. This community of international lawyers devoted to the research and study on law of the sea and environmental issues. So for me is really a very happy moment. May I add that in particular I give a special thank to the Chinese friends who are here and give us a very important perspective of their analysis on these issues. And finally, the journals which are in a certain way mentioned here, and in particular, of course, the Maritime Safety and Security Law Journal. Bon anniversaire, 10 years of the existence of this journal, created and directed by a group of female colleagues, all of you are, yes, which gives a special, may I say, significance to this journal, and also to the marine development, edited by the Ocean University of China, where I have the honor of teach sometimes. And these two journals, I think, testify, may I say, the constant interest which these topics deserve. And luckily they, may I say, go on in interesting also younger generations. International courts, of course, are playing a very important role in shaping global responses to climate change. We have 3,000 of climate proceedings all over the world. Of course, I'm talking of mostly of internal proceedings, domestic proceedings, and in particular, most of them are in the United States of America. But nevertheless, the fact that there is this activity is very important because there is a sort of development in the conscience, in the special definition of obligation of states and corporations. Don't forget corporations, to prevent environmental harm and protect human rights. And so we have some recent cases. They will be analyzed in a moment by this very high-level panel I have the honor to chair. There are these recent cases which have some, may I say, common grounds, common achievements maybe. First of all, they all address states' obligation regarding climate change under international law. And this is the first point, because I'm speaking in particular of the advisory opinions, because this morning we will have three analyses on different international tribunals, the advisory opinion, and the final one on a contentious case of a regional court, European Court of Human Rights. But beginning with the three advisory opinions, it is very important because the fact that they were asked to clarify existing international legal obligations, not to create new law, of course, interpreting them, which is very useful for the development of this area. Secondly, they all connect environmental protection with human rights. This is another important aspect. They emphasized states' duties of due diligence and prevention. They interpret specific regimes in the light of special agreements, in particular Paris agreements, and scientific findings. Scientific findings as a sort of compass to follow. They reflect a global judicial trend toward the so-called climate accountability. So it is very important that these three opinions, of course they are opinions, but opinions released by very important international tribunals, they have clarified, even if they are opinions, they have clarified that states have legal duties, not just moral or political duties. This is very important, in my opinion, to stress, because there are many attempts, I speak in particular of some Italian domestic decisions, to interpret these duties as political ones and therefore not subjected to judicial review. And this is very dangerous in my humble opinion. So it has been clarified in this and in other decisions how cooperation is necessary among states, because how can we fight climate change without the participation of the major, the states who used to favor climate change because of their industrial activity. So the cooperation is compulsory, it's not a choice. Okay, there is no choice. These decisions, of course, contribute to what we call cross-fertilization among judges. So it is very important, the relationship among them and how they take care of previous judgments. A systemic interpretation of all the rules which are at stake in this framework, and something which I like very much, the demonstration that in this, as in other fields, there is no fragmentation of international law. We know that this word is very popular, fragmentation, self-contained regime, and so on. It has been shown by these tribunals that there is no fragmentation. We have to put together all the relevant laws, treaties, customary principles, and so on, in order to define specifically duties of states and corporations, and so give them a sort of, may I say, route to follow. I am very happy to have this high-level panel to chair, because we will be, I think, introduced very deeply to these issues. The first panelist, the first person which will take the floor is Professor Ida Caracciolo. Professor Ida Caracciolo is nowadays judge of International Tribunal of the Law of the Sea since October 2020, but has served for many years in the Italian Ministry of Foreign Affairs as a consultant, and so has a long-standing experience on these issues, in particular on the law of the sea. And is a full professor of international law at the University of Campania Luigi Vanvitelli since 2005. She will deal with the ITLOS Advisory Opinion on Climate Change and International Law. Ida, the floor is yours for about 20 minutes.
Good morning, everybody. I wish to start by thanking the Italian Consiglio Nazionale delle Ricerche, and in particular Gemma Andreoni, for having invited me to speak in this conference. I'm a little embarrassed of speaking about the advisory opinion, because of course there is a sort of, I need to remain close to what has been written in the advisory opinion. So I will just highlight some points which, in consideration of this conference, I considered more interesting. The first point I will introduce to you is the relationship between the UN Convention on the Law of the Sea and the treaties on climate change. You should know that many participating states to the procedure at the written phase and or at the oral phase submitted to the tribunal very different positions concerning the applicability and relationship between the convention and the climate change system. Some states thought that only the climate change treaties should be applied concerning the effects of climate change to the marine environment. Other supported the position that only that the convention was a sort of empty box concerning this aspect, which could be filled up with substantial rules contained in the climate change system. Other presented to the court the position that, to the tribunal, the position that only the climate change treaties should be applied, and in particular, one of them, the agreement, the Paris Agreement, was a lex specialis vis-à-vis the UNCLOS. And there are other positions more shaded than these I have just described to you, which were the more extreme in a certain way. So the tribunal had, of course, was of course obliged to answer these different proposals or reconstructions, and it take into consideration, of course, the fact that the tribunal is a judge whose jurisdiction concerns the interpretation and application of the convention. It's not a judge having a general jurisdiction concerning all international law, customary and conventional, whatever convention will be involved. So the tribunal concluded on that point that UNCLOS is not closed in itself, it is open, and this openness of the convention is permitted by the rules of reference, which are contained in the convention itself. Some of them are general, others are provided for in the field of environmental protection, the protection of the marine environment. Then the tribunal also applied the Vienna Convention on the law of treaties, and in particular Article 31, para 3, letter C, which, as you all know, consists in a general rule on interpretation of treaties, which requires states to take into account, together with the context, of any relevant rules of international law applicable in the relations between the parties. And therefore, the tribunal didn't interpret the 1982 Convention in isolation, but taking into consideration, interpreting it through some provisions, in particular some provisions contained in the UN Framework Convention on Climate Change and the Paris Agreement. Another point which was faced by the tribunal was the role of science. You can easily understand that in a field dealing with pollution or dangerous effects of climate change on the marine environment, it's extremely necessary to have a sort of scientific idea of the polluting or endangering scientific mechanisms. And you also know that the relationship between international judges and science is not an easy one. But in this field, the tribunal was in a certain way assisted by the fact that it wasn't called to find out the good science, because the scientific community rather entirely is involved in the activities of the Intergovernmental Panel on Climate Change. So the science was given exclusively, is given exclusively in this field by the IPCC. Therefore, the tribunal hadn't hadn't the need to choose one science instead of the other, of another, and it based its legal reasoning on the conclusions reached during the years by the IPCC, and in particular, in some paragraphs, the advisory opinion highlighted that the IPCC reflect the scientific consensus in the area of climate change. And anyway, the tribunal also added that in case the science weren't sufficiently developed and consolidated, anyway, the precautionary approach is an approach which could be helpful in guiding states while facing the protection of the marine environment from climate change. A third point I would like to deal with, extremely important for the advisory opinion is, of course, the obligations upon states in the field of protection, in general terms, of the marine environment from the dangerous effects of climate change and in particular greenhouse gases. The tribunal had in front of it part 12 of the convention, which is devoted to the protection of the marine environment, but also some other articles, since the request for an advisory opinion wasn't focused only on part 12, but requested the tribunal to find out obligations in the convention in its entirety, and not specifically only in those obligations established in part 12. And the tribunal identified a certain number of obligations, in particular, the obligations contained in Article 192, in Article 194, in Article 197, in particular, this article cooperation in the field of the protection of the marine environment, and other articles. The intervening states proposed many interpretative solutions to the tribunal. So the tribunal navigated through these suggestions from intervening states. If you read the the written interventions or read the text of the hearings, the oral interventions, you will see that most states supported the idea that most obligations contained in Part 12 were obligations of conduct. Few, a minority of states supported the idea that some of these obligations were obligation of result. But also some states stressed the opinion that there could be a tertium genus obligation neither of conduct, neither of result. Since many articles are written in the Convention in a way that they not only describe the conduct, but also a possible result to be possibly achieved by the conduct described wherein. So the tribunal analyzed very attentively these proposals and interpreted in a very analytically the convention and concerning the obligations to preserve, protect the marine and reduce pollution of the marine environment. The tribunal, first of all, concluded that the pollution caused by greenhouse gases is pollution, can be considered a kind of pollution included in the definition of pollution given by Article 1, paragraph 4, subparagraph 4 of the Convention. And then concerning the obligations upon states to prevent, reduce, and control pollution of the marine environment contained in Article 194, paragraph 1, the tribunal traced the following elements. First of all, take into consideration the kind of pollution caused by greenhouse gases. It's not exactly a problem of reducing or eliminating the pollution, since the immediate cessation of the marine pollution from anthropogenic greenhouse gases it's impossible on the basis of what the science tells the jurist and the tribunal in particular. Even if tomorrow the effects would be interrupted, the production of the pollution would be interrupted. Anyway, the effects will last for many years to come. So the idea is to interpret this article, take into consideration the scientific context and the big number of pollutants already in the atmosphere and in seas and oceans because of greenhouse gases. Then the tribunal highlighted that states are required to act even individually or jointly. There is no priority between one way of acting and the other, since the Article 194 proposes both as appropriate. Then the tribunal reflected on the measures necessary to protect the marine environment and against GHG's pollution. And the tribunal didn't trace out specific measures, but it highlighted how to find the measures, take into consideration the science, relevant international standards and international rules, not only those contained in UNCLOS, but also in Paris, in the Paris Agreement, and then in the UNFCCC, and any other relevant factor, the best practical means at disposal to states, and in accordance with states' capabilities. And then, of course, the tribunal faced the main issue, which is obligation of conduct, obligation of result, and the tribunal concluded that this article, but as well Article 192, Article 197, for example, are establish obligations of conduct. On that aspect, the tribunal followed its jurisprudence already contained in two advisory opinions given by the tribunal in the past, one on the obligations of sponsoring states in activities concerning deep seabed mining, and another concerning IUU, illegal, unreported, unregulated fishing activities. And the tribunal, therefore, repeated that there is a strict connection between obligations of conduct and due diligence, which means, in particular, in this field, to put in place, I'm reading the paragraph in the advisory opinion, a national system, including legislation, administrative procedures, and an enforcement mechanism necessary to regulate the activities in question and to exercise adequate vigilance to make such a system function efficiently with a view to achieving the intended objective. So you see a sort of global range of measures that states are required to put in place at various levels: legislative, administrative, and adjudicative fields. The standard of due diligence must be, according to the tribunal, defined in an objective manner, and even if it is an evolving standard due to the evolution of science, of technology, and also the modification of states' capabilities along the years. In order to have this standard as much objective as possible, the tribunal indicated some factors to be considered. Again, the science, again, the relevant rules and standard, the risk of harm and urgency. And the tribunal added that this standard is stringent. These are the exact terms utilized by the tribunal. The standard is stringent, so all states are called to respect the stringent standard. However, the means can be variable, take into consideration states' capabilities and the means at their disposal. Another aspect the tribunal, and I will conclude, stressed was the obligation to cooperate. Also, to that end, the tribunal utilized its jurisprudence. It had already, for example, in the Mox plant case, referred to the need of cooperation in the protection of the marine environment. And the tribunal reiterated this position, and it considered that the duty to cooperate is provided for by Article 194 itself, but also by other specific rules contained in the Convention, and in particular 3 articles, 197, 200, and 201. We don't have time to analyze the paragraphs devoted to that issue in the advisory opinion, but what's I think is interesting is to recall you that the tribunal held that this duty is customary, is established already by customary law, that the obligation contained in Article 197 is an obligation of due diligence, and which must be assessed by reference to the efforts made by states to formulate and elaborate international rules, standards, and recommended practice and procedures, as it is indicated in Article 197. And also it is interesting to remember that this obligation is an obligation of ongoing nature. It means that if a state has participated to one conference, it hasn't complied definitely with this obligation, because this is an ongoing obligation. It requires continuous efforts to adopt, modify, refresh rules and standards, multilaterally, bilaterally, within international organizations, or not. And then the last point, which is Article 192. This is a very short article, just one line in the Convention, but it was very important because it is useful for the protection of the marine environment in cases where we don't have pollution, but we have other kinds of dangerous effects by climate change on the marine environment. And the tribunal interpreted in a sort of evolutive manner the terms contained in this article, in the sense that the exact terms in Article 192 are protect and preserve, to protect and to preserve, and the tribunal considered that preservation includes restoring marine habitats and ecosystems where the process of reversing degraded ecosystems is necessary in order to reach again the ecological balance. And then that conservation, the term we can also have a conservation which includes mitigation, adaptation, and resilience building, and maintaining living resources. Even if adaptation is not provided for by UNCLOS anyway, by reference and interpreting UNCLOS under the light of Paris Agreement, adaptation could be an obligation within one of the obligations established by Article 192. And since we are speaking here about biological diversity, in interpreting Article 192, the Tribunal, and also in interpreting Article 194, paragraph 5, for the protection of rare and fragile ecosystems, the Tribunal referred to the Convention on Biological Diversity concerning the definition of habitat, and made reference to the CITES Convention concerning the definition of species. The Tribunal gave an overall interpretation, mainly of Part 12, and maybe some of the concepts, some of the interpretation followed by the Tribunal could also be helpful for future hypotheses of pollution, of dangerous effects to the marine environment, since it was the first time that the Tribunal was called to interpret in such a massive, I will say, way, Part 12 of the Convention. Thank you.
Thank you very much, Professor Caracciolo, for your speech, for having, first of all, respected the time at your disposal, and then clarified to ourselves which were the main positions maintained by states for this important insight on the interpretation of precautionary principle, and for having clarified how important was to interpret, in particular, UNCLOS in this wide sense, but respecting may I say, the intention of the drafters of the convention, which was to also to imagine this sort of evolution, which is inevitable, and how the standard you mentioned, the stringent standard, can be considered as usual a sort of minimum standard. So states are invited to even to do more. But anyway, we will see which will be the future. But thank you, because it is very, very, very important. Having had this analysis of this advisory opinion, which having connected law of the sea and environmental issues, climate change, gives us the opportunity to imagine also other developments in other situations of the same kind. Once again, the function of ITLOS in giving advisory opinion has been strengthened in this occasion, because, as we know, it is something that was invented by the Tribunal itself, but I think with this opinion, I think an important step towards the efficiency, the general acceptance of this competence has been achieved. Now, I have the pleasure to give the floor to Philippe Gautier. Philippe Gautier now is the registrar of the International Court of Justice, but before he was the registrar of the Tribunal for the Law of the Sea, and he has been also engaged in activities in the Belgian Ministry of Foreign Affairs, but is a professor of at the Catholic University of Louvain with a long activity in studying and writing on many issues, in particular on environmental law, Antarctica law of the sea, settlement of disputes. So it is really a pleasure also because, and I am happy to remind this, he is a friend of the International Association for the Law of the Sea. Philippe, the floor is yours.
Of course, I wish to thank the organizers of this symposium for their kind invitation, in particular Gemma Andreone. When Gemma mentioned this a couple of months ago, it was supposed to be a round table or a seminar, but I'm really impressed by the fact that it has been prepared as a full-fledged conference symposium. This congratulations, and it's a pleasure to be here. And it's a pleasure also to speak under the leadership of Giuseppe Cataldi, because we were together in Napoli 25 years ago for the beginning of the Association Internationale du Droit de la Mer. Sweet memories. Well, I will present in 15-20 minutes the advisory opinion of the court concerning obligation of states in respect of climate change. I wish, first of all, to adopt a precautionary approach. We are in environmental matters, but I start with a disclaimer. Everything I can say reflects solely my personal opinion. I will more act in an academic manner, in a sense, even if I cannot hide my other affiliation. Well, what I intend to say is first a few words on the historical and procedural background of the case, as well as some comments on the questions submitted to the court before addressing the contents of the advisory opinion. Of course, you should understand that within 15-20 minutes, I will not summarize 133 pages and 12 opinions and declarations appended to it. I will only focus on some aspects, and there is certainly an element of subjectivity attached there too. And if you consider then some aspects which should have been addressed are missing, well, put the blame on me. As regards the historical background of the case, you know that it started with a group of students, Pacific Island students fighting climate change. And it was followed by an announcement by Vanuatu in 2021 of its intention to seek an advisory opinion from the court. And this idea gained support, in particular with small developing countries. Of course, it's not sufficient to bring an advisory opinion before the court, especially with the General Assembly. You need a majority from among the 193 member states. There was an intense lobbying in New York, and as a result, the draft resolution was sponsored by 132 states. That's a record, and it was adopted without a vote. I mention that simply to underline that persistent efforts by small states, of course, when some conditions are met, may produce successful results. No, in terms of procedure, this case is also unprecedented with the level of participation. There were 91 written statements filed. That's a record. It's unprecedented for an advisory opinion. There was a second round of written statement with 62 comments. And during the hearing, which lasted for 2 weeks, 107 states and international organizations participated. This is quite an achievement. Well, at this stage, I would like to refer briefly to the 2 questions submitted to the court. The first question reads as follows: what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? This addresses primary rules of international law. The second question, question B, relates to the responsibility of states for breach of those primary rules. And the question reads as follows: what are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment? Well, the second question is a bit longer. It asks the court also to address the situation of small island developing states, which are, as you may realize, particularly vulnerable. But the court noted in this respect that the law on state responsibility doesn't make a distinction between the categories of injured states. Therefore, if there is any difference, it should be addressed at the stage of primary rules of international law. There was also another addition in the second question dealing with responsibility. That was the specific situation of peoples and individuals. There also the court simply observed that the possibility for non-state actors to bring an international claim against a state is regulated, is addressed, and depends on the conclusion of specific treaties on this matter, which would create procedural and substantive rights. That's for the question. Now, I will mention a few comments. My first comment relates to the role of science, and here there are similarities between the opinion of the court and ITLOS, and there are 2 points there. First, in its opinion, the court relied primarily on the report issued by the International Panel on Climate Change, and I quote, which, participants agree, constitute the best available science on the causes, nature, and consequences of climate change. And those who are familiar with the website of the court would have noted that there was a press release issued before the hearing on a meeting between members of the IPCC and members of the court, or experts of the IPCC, and that shows that the court considered it really important to be fully aware of the scientific background relating to climate change. My second point is to refer to the conclusion of the IPCC, which is underlined by the court, and the conclusion is that adverse impacts from climate change will escalate with every increase in centigrade, and that those adverse impacts are higher for global warming of 1.5 centigrade than at present, and even higher at 2 centigrade. And we may relate this finding at the beginning of the opinion with paragraph 224 of the opinion, in which the court notes that, I quote, while the Paris Agreement provides for limiting the global average temperature increase to well below 2 degrees, above pre-industrial levels as a goal, and 1.5 degree as an additional effort, 1.5 centigrade has become the scientifically based consensus target under the Paris Agreement. That's the finding of the court, The finding is that 1.5 threshold is the parties' agreed primary temperature goal. This finding is not only based on a scientific approach, of course, it is based on what the court considers subsequent agreement reached during the conference of parties, subsequent agreements relating to the interpretation of the Paris Agreement. Second comment, applicable law, regarding the applicable law, and here also two points. First, there are a number of text instruments addressing climate change. And even if you look at the resolution, submitting the questions to the court in the chapeau before the two questions, there is a reference to a number of instruments. Thus, there was a need for the court to make a choice and to identify the most directly relevant applicable law governing the question, and you may find the list in paragraph 172. Second, and I refer here again, as it was done in the case of ITLOS, to the so-called lex specialis issue. Given the existence of the climate change treaties, this means the UNFCCC, Kyoto Protocol, and Paris Agreement, which specially address climate change issues, some participants argue that and raise the question whether the rules contained in these treaties would take precedence over other rules of international law. That's the idea of a self-contained system, in a sense. And the consequence is that a state which would comply with those treaties, climate change treaties, would fulfill their obligations under international law. There, on this issue, the conclusion of the court is clear. There is no indication that the climate change treaties are meant to apply while simultaneously excluding general customary international law or any other treaty on the protection of the environment. Because there are two sets of rules, basically treaty law, customary law. Now, third comment, I will refer briefly to the obligations of states under the climate change treaties. And here, in my view, this is a very important contribution of the court, in the sense that the court clarifies the nature of the obligations contained in those treaties. And that was already mentioned by Giuseppe Cataldi. Those treaties do not set out vague obligations. On the contrary, they put into place a robust set of rules which cannot easily be complied with. And the court will take the time to explain this point in a pedagogical manner, going through the main relevant provisions contained in the treaties. For example, if you look at the UNFCCC, the obligation that the parties, all parties, have the obligation to develop periodically, update, publish, and make available national inventories of greenhouse gas emission. This obligation, as well as other obligations contained in the UNFCCC, are characterized by the court as obligations, binding obligations under international law, and as obligations of result. In this respect, there are interesting developments in the opinion on the difference between obligations of result and conduct, but at the same time, the court underlines that this distinction should not be overestimated. Eventually, all obligations, either of conduct or of result, have to be complied with. That's what matters. That being said, the court also adopts a similar approach vis-à-vis obligations in the Paris Agreement, and it's particularly important because if you read the Paris Agreement, you realize that it's not drafted on the classical model of treaties. The language used is a bit different. And here the court clarifies that those obligations are really binding. And just an example, if you look at the nationally determined contributions, the NDCs, that each party, all parties to the Paris Agreement, have to prepare, communicate, and maintain. The court underlines that it's a binding obligation, that it's not only a formal obligation, the content is also important of those contributions, and the content is not left to the discretion of parties. Indeed, those NDCs must represent a progression beyond the party's current NDC. The NDCs must be capable of making an adequate contribution to the achievement of the temperature goal, and all NDCs together must be capable of realizing the objective of the agreement. Thus, they are subject to a test, and compliance may be assessed. 4 comments regarding the other set of obligations, that the customary law obligations. I will only comment on the duty to prevent significant harm to the environment. And here, an important contribution of the opinion is to address the question whether this duty, the duty to prevent significant harm, is applicable in the case of climate change. It's a specific situation, climate change and the consequences related thereto, because it's caused by cumulative effect of different acts undertaken by various states and by private actors. And the response of the court is in the affirmative. In other words, the obligation of prevention in environmental matters is not limited to case of classical transboundary pollution between neighboring states. That was argued by some countries during the proceedings. And it's not a novel idea. In the opinion, the court refers simply to its opinion on the legality of nuclear weapons, where this point is already made. I would add that the obligation to prevent significant harm to the environment cannot be discharged so easily. It's not a vague obligation. And the court explains that states must act with due diligence, that's the due diligence standard which applies, taking into account the scientific knowledge. The due diligence standard will depend on the specific situation of each state, and every state has to take all means at its disposal. States need to take appropriate measures, and appropriate is not a vague abstract term. It means to take measures designed to achieve the goal under the Paris Agreement. And these measures also include procedural elements. Very important, those procedural elements concerning obligations of to consult, to notify, to conduct environmental impact assessment, for example. My 5th comment, and I have 7 comments, I'm approaching the end. My 5th comment concerns the relationship between obligations arising from treaties and from customary international law, since the 2 sets of rules are applicable in parallel. And in this context, I will only address a specific point. That's the situation of states which are not parties to the climate change treaties. Of course, those states have to comply with their obligations under customary international law, but how to define those obligations of prevention, for example, and how to assess whether the states will comply. And there, the opinion, I would say, brings some elements of response. For example, the opinion states that the customary obligations of any state which is not a party to these treaties find expression, at least in part, in the general practice of states, which is in accordance with their obligations under the climate change treaties. You see, in other words, the contents of the treaties, of those treaties, inform the way international obligations under customary law have to be conceived, have to be applied. That's an important contribution. 6, here I will mention briefly 2 points, but as an illustration, as a sample of additional matters dealt with in the advisory opinion, but I don't want to spend too much time on that. First, as regards law of the sea, you may note that in a brief paragraph, that's paragraph 363, the court refers to the threat that sea level poses to the territorial integrity of some states, and basically small island states. And there is a statement according to which, I quote, once a state is established, the disappearance of one of its constituent elements would not necessarily entail the loss of its statehood. Well, I will disappoint you because I don't intend to offer any comment on this issue. I will simply refer you to the opinion of Judge Tomka appended to the advisory opinion that would create the terms of a discussion. The second point is the relating to human rights issues, which are, of course, very important. There are consequences for human rights resulting from climate change. And one contribution of the advisory opinion is the affirmation by the court that under international law, the human right to a clean, healthy, and sustainable environment is essential for the enjoyment of other human rights. And here the court refers to the practice of state, regional practice, and also the terms of Resolution 76-300 of 28 July 2022. 7 point, we are approaching the end, that relates to the responsibility, and that's the subject of the second question submitted to the court. Here I will make 4 points. 1, the court makes it clear, and it has to be underlined 3 times, that it has been requested to address legal consequences of climate change in a general manner. And it's not called upon to identify the legal responsibility of any particular state or group of states. That would require an analysis on a case-by-case basis. And if there are questions relating to the advisory opinion, I think the only solution is to bring the matter to the court. 2, some participants argued in the context of climate change that general rules on state responsibility would not apply. There would be special rules which are contained in the climate change treaties. Here, the response is quite simple. The court doesn't find in those treaties any intention of the parties to exclude the rules on the general rules on responsibility. An example, Article 14 of the UNFCCC, that's the dispute settlement clause, doesn't refer to any specific rules which would have to be applied among the parties. 3, we need to recognize that climate change is a highly complex phenomenon involving possible responsibilities for multiple states over a long period of time. And climate change also results from not only anthropogenic source, but also natural source. That's a complex situation. And the court acknowledged that this may raise delicate, issues of attribution, causation. However, for the court, the rules on state responsibility under customary international law are capable of addressing these issues. For example, when there is a situation with a plurality of injured or responsible states. And science may also contribute in this respect. Fourth comment, last but not least, the court affirms that certain obligations applicable in the climate change context are erga omnes obligation. For the court, all states have a common interest in the protection of global environmental commons, like the atmosphere and the high seas, and consequently, states' obligations pertaining to the protection of the climate system, in particular the obligation to prevent significant transboundary harm, no harm principle, those obligations are obligations erga omnes. That has important implication when it comes to law of state responsibility, locus standi. But it's an advisory opinion. Well, just to conclude, after those 7 comments in a nutshell, I would say that the advisory opinion certainly does not contain anything revolutionary, but in a sense it's not what you expect when you ask such a question to the International Court of Justice. But that is precisely what makes the opinion a solid opinion. The court explains the different obligations, and I would say its main contribution is to explain that environmental law as such and the principles of environmental law are applicable to climate change. And in doing so, the court is building on its past jurisprudence, also the jurisprudence on other courts, and Tribunal and ITLOS has quite in a number of paragraphs referred to the advisory opinion, and therefore its opinion is based on solid ground. Thank you for your attention.
Thank you very much, Philippe, for your speech, for your 7 comments. They were all very interesting and important for ourselves. May underline how, as Philippe Gautier told us, everything began with 27 students in a classroom in a little place, in a little island in Pacific Islands. I want to underline this because we must be conscious how important is public opinion movement, because sometimes we believe that everything is useless because who decides is governments. But we, especially in these difficult days we are all living all over the world, I think we should be more involved and conscious of all this. How far can we go in convincing, maybe in conditioning the policymakers? Really, we have to appreciate what was done by these students, and then by, of course, the little island states in the Pacific, when they managed to go to the General Assembly and then to the International Court of Justice. Another very interesting issue is the issue of statehood. You only mentioned it, but it is enough for us to give a sort of food for thought, because it is an open question, very interesting and difficult question, which has also some consequences for example, concerning the system of baseline in determining territorial sea and other spaces under sovereignty jurisdiction of coastal state, because how far can we go in derogating from the principle terra dominat mare and change our attitude because of course, the minor responsibilities that these states have in climate change and this kind of consequence for what concerns sea level rise. Anyway, I think I completely share your opinion on the fact that this is a solid opinion, which, as you mentioned, has nothing in particular which is so new, but has clarified to all which are the substantial and procedural obligations of states. And so it is really a sort of landmark concerning customary as well as treaty law interpretation. Now we go from universal jurisdiction to regional tribunals. Now we have another intervention concerning advisory opinion. The advisory opinion given by the Inter-American Court of Human Rights on Climate Emergency and Human Rights. Gianfranco Nucera from Sapienza University of Rome will deal with this issue. Gianfranco teaches environmental justice and climate change law and space law within the master degree international relations, expert international protection, human rights at the United Nations High Commission for Refugees. Okay, this is another very, very important point for our first panel. So, Gianfranco, please, the floor is yours for about 20 minutes.
So, good morning, everyone. Thank you very much, Professor Cataldi, for introducing me. And of course, like those who preceded me, I would like to thank the organizers, and particularly Dr. Gemma Andreone, for inviting me. Of course, it is an honor to have the possibility to speak today here with these distinguished speakers. And of course, I listened with great interest their intervention. I will try to make a small contribution on the debate by analyzing some specific issues of the advisory opinion on human rights and climate change. I have prepared a PowerPoint presentation. So, as you know, on May of this year, the Inter-American Court of Human Rights adopted its advisory opinion number 32 on climate emergency and human rights, to use the word climate emergency. I would like to start with the background of the opinion, because it's important to underline that Chile and Colombia sought clarification on 20 issues, so it was a very huge questions raised to the court, and the court decided to reorganize the advisory opinion into three main questions. The first related to substantive rights, the second related to procedural rights, and the third point was devoted to the obligation strictly related to equality and non-discrimination, particularly concerning vulnerable groups. We perfectly know the situation of Latin America, and the innovative case law of the Inter-American Court of Human Rights is related to the recognition, for example, of nature as a subject of right, or the importance given to natural resources and indigenous people. I must say also that the process that led to the adoption of the advisory opinions was the broadest in terms of participation. with written intervention from 263 actors, including 9 states. So it was a very huge participation. And also, it's important to note, concerning also what Professor Gautier said before, the role of science, that the court heavily relied on the reports of the IPCC in order to have a sort of technical legitimacy to explain also the innovative interpretation given to some specific norms. Concerning substantive obligation, the court recognized that the climate emergency altered the obligation of states and makes a specific reference to proactive measures and a concept of enhanced due diligence, which seems to be very, very innovative. But if we look carefully the advisory opinion, it's almost the same approach used by the ITLOS or the same approach used by the ICJ concerning the due diligence. There are few specifications. For example, the court says that the states must adopt a meticulous assessment and use the best available science and knowledge at their disposal, but this is almost the same position adopted by previous advisory opinion. Regarding procedural obligation, the court emphasized the necessity for state to ensure access to information, public participation, and legal remedies related to climate issues. And it's important to recall the Escazú Convention of 2018, which is the most important treaty related to these 3 pillars in Latin America. So also in this case, the innovation are related to many legal instruments adopted before the adoption of the advisory opinion. The third key obligation relates specifically to vulnerable groups, and here the approach is quite different because the court makes reference to an intersectional approach to be taken in order to recognize the disproportionate impacts on vulnerable groups and to take tailored action in order to prevent violation of rights of vulnerable groups. So this is in general, the three aspects that the advisory opinion of the court addressed. But I want to discuss with you and share with you some consideration that really attracted my attention when I read the advisory opinion. And particularly, it is the first time that the prohibition of causing irreversible damage to the climate system and the environment is qualified as a peremptory norm of international law. So it's something very innovative, which represents a significant progressive development in the evolution of international case law. But, which is the rationale that the court used in order to declare the prohibition of causing irreversible damage as a peremptory norm? We need to point out that this recognition is the last step of a pathway, because also in previous jurisprudence, the Inter-American Court of Human Rights tried to make this statement. For example, if we look at the advisory opinion number 23 of 2017 on the environment and human rights, in my opinion, that advisory opinion poses the basis for this kind of declaration, because also in that case, the court recognized the undeniable relationship between protection of the environment and realization of human rights. So it is like a functional link that the court used in order to assess the validity of environmental rules. And I mean, also this functional link is perfectly in line with the development we have in the international case law. In subsequent decision, for example, I can recall the Habitantes de la Roya versus Peru. In that case, the court specifies that arbitrary conduct that causes severe irreversible environmental damage bear the greatest importance, and that the protection of the environment requires the recognition of prohibition of such conduct as a peremptory norm. So it is like a declaration of will in this case, but in that specific case, the court didn't declare the prohibition as peremptory. The idea of the court is to also link this relationship between protection of environment and human rights, the growing recognition of prohibition of transboundary damage as an erga omnes obligation, and scientific consensus in order to make a unique approach to understand the significance of this prohibition. The logical assumption used by the court regards the necessity of a peremptory prohibition not to significantly alter the ecological balance. So its legal protection is essential to guarantee human rights. The court says including peremptory human rights. And to confirm this assertion, the court makes an hypothesis. If there is no peremptory prohibition in international law concerning the environment, irreversible damage to the environment, the situation would undermine the essential condition for enforceability of fundamental rights. So it's a logical necessity. This is something that recall in my mind the position of the former vice president of the IACHR, Judge Veramantri, when he, in its separate opinion in the Gabjikov-Nagimarosh case, refer to sustainable development as a principle of inescapable logical necessity. So the idea of necessity to justify to recognize the status, but of course in that case was a general principle. Now we are talking about peremptory rules, so it's quite different. Effectiveness is another concept used by the court in order to explain that protection of the environment is a conditio sine qua non for compliance with human rights obligation. In other paragraph, the court says that this obligation is a manifestation of the collective interest of humanity, as there is no other way, using this word, to guarantee the enforcement of human rights. So we have also the idea of necessity and effectiveness. I mean, by adopting this logic, it seems to echo the interpretative principle of effet utile, of course, which is an interpretative principle that requires the provision to be interpreted in the most effective way to achieve its purpose. In this case, the reasoning goes beyond this mere interpretation to define a sort of useful effect of the norm. To be effective, norm must be peremptory. Within this context, of course, we need to recall the main elements of peremptory rule in order to understand also the methodological approach of the court. And I will not recall all the main elements because we all are aware of the elements of jus cogens, of course, but in my opinion, according to the most prominent scholar, the element of acceptance and recognition is the most important element. It also, this can be understood also by the work of the International Law Commission on the draft conclusion on identification and legal consequences of peremptory norms of general international law. Because in that work, the Commission specified the importance of acceptance and recognition, and also clarified that the acceptance and recognition required for peremptory rule is different from the acceptance and recognition required for the identification of customary international law, because it is directed to prove non-derogability of the norm and not the general, also only the general acceptance. So these are the two elements in order to understand that whether no derogation is recognized, and the determination of such elements involves, according to the word of the ILC, the weighing and assessment of evidence. So it's not sufficient merely to assert the importance, the role of the norm in order to declare the prohibition as peremptory. And this test, this threshold, of course, is very high, and we must specify that it does not need a consensus among all the states, but the relevant practice should be representative of a vast majority of states, which means, of course, significant for regions, legal systems, and cultures. So coming back to the advisory opinion, we can say that from one side we have the International Law Commission that use a very inductive approach in order to prove, looking at the practice of state, in order to prove the existence of a peremptory norm. I mean, looking at the case law of the Inter-American Court of Human Rights, we can see that the approach used by the court does not follow very strictly the criteria identified by the International Law Commission, because it many times relied on the importance of the norm. For example, if we look on the advisory opinion number 20, on the obligation in matter of human rights of a state that has denounced the American Convention, the court described jus cogens as the legal expression of the international community as a whole based on universal and superior values. So it didn't mention the acceptance and recognition. So it seems to be more a deductive approach that, according to the court, it is necessary to protect fundamental values of the international community. In other cases, the court adopted a more functional approach, the one I recalled before of necessity. So it's necessary to protect. In that specific case, we have, a combination of approaches. We have a recognition of the superior value of the importance to protect the environment, and then we have also a brief assessment of international practice. The court looked at domestic acts, judicial decision, and also position of states within international organizations. But this assessment of the practice made by court seems to be directed toward proving that the prohibition does not conflict with current state of the art, and this is expressly stated by the court. So it's important to prove that it's not contrary to current state of the art, which is something very, very different. So, looking at this context, one can wonder if, and some other question, if we are looking at a possible regional norm of use cogent, which is a very difficult concept, and I mean, I have also some doubts about the possibility to use the concept of regional use cogents because of the possible conflict that can be between the universal nature of peremptory norm and the regional nature of a possible regional norm of use cogents. The ILC, the International Law Commission, adopted a pragmatic approach. So they exclude the topic of regional use cogents from its work because this issue does not align with the universalistic aspiration of the activity that characterize the activity of the International Law Commission. But looking at the previous jurisprudence, not the court, but the Commission, the Inter-American Commission of Human Rights, we know that in 1987, the Commission declared the prohibition of execution of minors as having the status of use cogents recognized by the member states of the Organization of American States. So it's a declaration that seems to be in the pathway to recognize the existence of regional use cogents. But I mean, many doubts remain on this possibility. I believe that looking at the advisory opinion at stake, it would be more appropriate to talk about a regional approach to the recognition of peremptory rule, which is something, of course, different. And my idea, I mean, is supported by the fact that the court always recalled the universal value of protection of the environment, never attached this value to the specific regional vulnerability of Latin America. So always emphasize the universal value of this prohibition. And also, when we can identify the functional approach and the idea of necessity, also in that case, a regional approach can, in the idea of the court, ensure the effectiveness of human rights protection. So it's something that has led to a certain vivacity of the court in the identification of peremptory rule. We have many, many cases of identification of peremptory rule. But then the consequence, the point is to clarify which are the consequences of this peremptory prohibition. We know that the violation of peremptory norm has significant legal consequences. We know when a treaty conflict with a norm is void, peremptory norms create obligation for all the international community. Serious violation entail further obligation in order to cooperate to remedy the breach. However, the court, when we arrive at the consequences, didn't attach the traditional consequences we know pertaining to peremptory norm to the prohibition of causing irreversible damage to the environment. And the court only reminds states that they have to cooperate to end the conduct that violates the norm. This limited effect, in my opinion, of peremptory norm as declared by the court, it seems to be more linked to a promotional effect of use cogents, particularly in the context of regional system. And there is, even in the wording of the advisory opinion, a sort of reluctance of judges in recognizing the full potential of peremptory norm. For example, when the court discuss about legal consequences says that states should cooperate and does not use a more resolute word, no, shall or must cooperate, which seems to be in contradiction to the asserted peremptory character of the rule. But then, looking also at this comparative approach used by the International Law Commission and the Inter-American Court of Human Rights, we must say that also the International Law Commission didn't exclude the possibility to have a peremptory norm concerning environmental protection. Because it is true that in the annex we do not have this prohibition explicitly inserted in the annex, but in the commentary of article conclusion, draft conclusion 23, the Commission recalled draft article 19 of the work on state responsibility adopted in 1976. So this possibility has been also recognized by the International Law Commission. We must, of course, say that after 2 months after the advisory opinion of the Inter-American Court, the ICJ did not follow the legal reasoning and the legal the approach used by the Inter-American Court of Human Rights, as Professor Gautier perfectly explained. The court referred to the concept of obligation erga omnes, which of course is a different concept with different legal implications. So it is something that remains more with like a declarative statement of the Inter-American Court of Human Rights. To conclude, and I think I stay in 15 minutes, this advisory opinion, in my idea, in my perspective, exemplifies, in a sense, the way and also the value of adopting a regional approach to identifying peremptory norms. And the idea is that this recognition could have a promotional effect, reinforcing, also looking at next panel, reinforcing the power of citizens, association, to promote strategic litigation before domestic tribunals. And in this sense, the Inter-American Court of Human Rights seems to try to start a dialogue with international and national courts that are invested with disputes concerning interpretation and implementation of climate obligation. And this point is also important, particularly in the Latin American system, also for domestic tribunals in Latin America, because of the control de convencionalidad, the conventionality test that is used by the Inter-American Court to assess the disputes. So this is my contribution. Thank you very much.
Thank you very much to Professor Nucera for this interesting speech on the Inter-American Court of Human Rights Advisory opinion. Of course, this court has a specific task concerning human rights protection. That's why there is a full concentration on human rights issues, more maybe than in other cases, in the case of other international tribunals, because it is a specific task, of course, of this court. Thank you very much also for having dealt with the central issue of jus cogens. The idea of regional jus cogens, of course, is a sort of oxymoron in my opinion, because if it is not universal, it is not discovered. So I share what you have said about the reasoning of the court. Yes, states should cooperate. This word "should" is unfortunately very present in many international documents, treaties, and decisions. But anyway, I think that step by step, as we think, as I think we have, you are demonstrating in this panel, this idea of obligations concerning climate change is taking place more and more in the international arena. Now we leave the field of advisory opinions. We remain in the field of regional tribunals because we deal with climatizing human rights, the judgment of the European Court of Human Rights in the case Klimaseniorinnen versus Switzerland and beyond. This is a very important, very interesting decision of the European Court of Human Rights. And I have the pleasure of introducing you, the speaker, who is Haritini Dipla, Emeritus Professor of International Law at the University of Athens, but also she has been a professor at the University de Genève. She has been president of the National Commission, Greek National Commission of Human Rights, member of the Scientific Council of AssIDMer, and many other things. But she's a known specialist in these issues, so I am very happy to have her here, to give her the floor for about 20 minutes. And please, Haritini, the floor is yours.
Thank you, Mr. President. And many thanks, of course, from me also to the organizers of this nice meeting here today. And first of all, Professor Gemma Andreone. Well, the title of the conference is from local to global. Now we are having here the opposite. We saw global first, and then we went to local. So I'm going to speak about a case within a very special framework, of course, in the European framework of the Convention of Human Rights, of the European Convention of Human Rights, whose anniversary is this year, the 75th anniversary since the time that the convention was adopted. And I would like to begin with saying to you also that I so much enjoyed what the previous colleagues have said, because for me it was a moment where I have realized how close are the fourth tribunals, how close in many aspects. Even if there are differences between them, some things, for example, about science, everybody, the case of Klimaseniorinnen is based on science. It is based on the conclusions of the ITCC. And so, as I was listening to you, I was saying, but this also, and this also, yes, it's true. But I have read, of course, the opinions, but it's different to have the all together, to put the four opinions together, the three opinions together, and then speak about the court, the European Court of Human Rights, which before ITLOS, Inter-American Court and International Court of Justice opinions, it delivered for the first time a judgment in respect to climate change
adverse effects on human rights protected by the Convention, especially the right to life, Articles 2 and 8, right to privacy and home. Now, in this case, as we have students also in this room, I shall speak a little bit about the case to see what happened afterwards. In this case, a Swiss law non-lucrative association, the Klimaseniorinnen, the Verein Klimaseniorinnen, Switzerland, active in the sector of climate protection and representing more than 2,500 elderly Swiss women, and 4 of its members complain of being victims of a breach of their human rights because they are and will be impacted by climate change-induced heat waves, facing the risk of heat-related mortality and morbidity. On its side, the NGO alleged also to be a direct victim of the breach, as its mission was to defend the rights and represent this vulnerable group, and he has also the mandate to prevent health hazards caused by such change. The applicant also claimed before the court that the refusal of the national courts to address their complaints was also a violation of Article 6, paragraph 1, right to the fair suit. Now, the judgment of the court delivered last year has already created different reactions in the work of academics and practitioners who have expressed comments about the groundbreaking, far-reaching, even sophisticated aspects of the judgment. It has also created great expectations to people of civil society. It has also provoked strong reactions by the responding and other states concerning the interpretation of the Convention, which is silent, as we all know, about the protection against climate effects, as far as the obligations of states parties are concerned. The first thing that the court did is to pronounce on its jurisdiction. In this legal landscape of an overlapping area between the human rights and international climate law, it recognized that although it has developed a rich jurisprudence in the field of environment, also not mentioned in the Convention, the specific characteristics of climate change, the regulation of which is attached to an issue that fundamentally concerns the separation of powers, judicial review of the conformity of this action with the state legal system is carried out internally by internal courts, by national courts, especially since these are national decisions of particular complexity, and they are political decisions. Or the states used to be convinced that those decisions are political or only political. That said, the court noted that it has to take under consideration the fact that when the complaints brought before it relate to human rights protected by the Convention, it is not solely a matter of political will or decision-making choices, but it rather falls within the scope of the interpretation and application of the Convention, which is, of course, within the court's jurisdiction. And in respect of this conclusion, the court referred to the intergenerational nature of terms of the distribution of efforts between generations, and in the fact that within the effort of fighting against climate change, without having had the opportunity to participate in the current decision-making process on the matter, future generations are ignored and risk bearing the growing burden of the consequences of the failure and omissions of the present generation, which is contrary to Article 3 on the United Nations Frame Convention of Climate Change. Now, the other interesting point was, of course, the legal status, the victim status of on the individual applicants and the locus standi of the association. Faced with the jurisprudential dilemma between real and effective protection in the European human rights framework and the exclusion of actio popularis in the domain of climate, where it's difficult to identify who is the victim. No one is the victim and everybody is the victim. It decided to establish a high threshold for the criterion of causality between the state's conduct and the direct or potential damage allegedly suffered by the individual applicants. So it applied two criteria for qualifying as a victim in the context of climate change. First, that there is an important and extensive exposure of the applicant to the adverse effect of climate change, and two, a compelling need to ensure the individual protection of the applicant. And the court said that the threshold as which these criteria are deemed to be satisfied is particularly high. In the particular case, while acknowledged that the heat waves had, of course, a negative effect on the applicant's life, it asked for a concrete and personalized proof showing that the claimants were affected by the state's inaction. In this case, it found that the four ladies had not provided evidence to show that they had been exposed to the adverse effects of climate change or that they were a risk of being exposed to such effects at any point in the future, or to the extent that would give rise to compelling need to ensure their individual protection, and ruled that their application was inadmissible for incompatibility ratione persone with the provisions of the Convention. In contrast, the possibility for organizations to represent groups of people, many of whom did not afford the costly expenses of international litigation, and to work for common good of present and future human societies, gives them a privileged position in the field of international climate litigations. Indeed, the court took under consideration that, according to its statutes, the association is a non-profit legal entity under Swiss law that was created to promote and implement effective climate protection measures on behalf of its members. It is highly representative. Its statute also provides that the association is involved in various actions aimed at reducing gas emissions in Switzerland and addressing the effects of this emission in global warming. Finally, it undertakes various initiatives, in particular bringing legal proceedings relating to the effects of climate change in the interest of its members. The association, and then again, says the court, fights not only for the interests of its members, but also for those of the entire population, considering the interests of future generations, with the aim of achieving effective climate protection. The court shall apply in this case the claimants have submitted application of Article 2 and 8, right to life, and Article 8 to privacy and home, etc. But in this case, the court chose to apply only Article 8, as, of course, it must be considered to encompass the right for individuals to have effective protection by the state authorities against the adverse effects of climate change on their lives, health, well-being, and quality of life. It excluded the parallel application of Article 2, since it finds that both articles contain similar elements, in particular because the environmental and climate obligation arising from the two provisions overlap. And this is a habit that the court had also in a few other environmental cases. Now, which are the obligations under human rights law regarding the effects of climate change? It's here we can see the interaction between the two groups of the two systems of law, of international law, human rights and climate law, because the court will say that in order for protection to be ensured in accordance to the convention, in a climate case, the state is obliged to abide to its commitments on climate law. And so it brings in the human rights the applicability of the law of the rules about climate change. So the court in the substantive part recognizes that the contracting states must put in place the necessary legal framework, legislation and other regulatory measures to prevent an increase in greenhouse gas concentrations in the Earth's atmosphere at a rise in the average global temperature to level that would have serious and irreversible repercussions of human rights, including the right to respect for family life and the right to a home guaranteed by Article 8 of the Convention. The duty of protection arising, therefore, obliges the state to take these measures in accordance with international climate change law, with a view to significantly and progressively reducing the gas emissions level to achieve net neutrality in principle in the next 3 decades. That said, this is the general. That said, the court does not limit itself to the general framework, but it will also present a more detailed list of the duties of states in this regard. The general criterion for the court assessment being whether a state has remained within the limits of its margin of appreciation. It demands concrete action through robust general measures in the context of policy decisions, of course, in abiding to international standards and consensus target. Here, it was the first court to have spoken about the consensus, which was in accordance to the IPCC, to the conventions on climate first, and to the ITCC conclusions after that. So it demands robust general measures in the context of policy decisions to abide international standards, and implementing measures in accordance to climate convention and relevant scientific conclusions. Adoption of a specific timetable for achieving carbon neutrality and compliance mechanism, quantifications, intermediate reduction targets, science-based target setting, for the first general obligations, the general context, the court said that the states dispose of a reduced margin of appreciation. On the contrary, on specific measures, the states should be accorded a wide margin of appreciation. And although it says that, it rejects the submission of the defendant state that adopting national determined contributions was in itself enough for abiding with the international commitments of the state of Switzerland. So it says that there is More specified are the targets, implementing rules. The state is within the large appreciation area. We shall see that this is the central problem in this case. And we shall see, because we shall meet again this problem within, during the execution period after the delivery, the case. And of course, the court, everybody was surprised, because I would never imagine that the first state that would be judged in the court would be Switzerland. Because as I personally had lived there for almost 16 years, I have done my studies there, I always have the remembrance that we have to stop our cars. When I was there 30 years ago, I mean, I had to stop my car on the red lines. I could never imagine that the Switzerland should be judged and condemned by the court. But let's go a little bit further. In this drama, it was a drama for the country and for other countries who intervened. So, after an examination of the Swiss climate legislative and administrative system, the court concludes that the legislation and its implementing measures contain serious shortcomings and do not meet the obligation of the respondent state, and that its efforts at the national level had not achieved the objectives set by the bodies of the Paris Agreement. And the court, of course, concludes that in failing to act in a timely, appropriate, and consistent manner in the design, development, and implementation of relevant legislative and regulatory framework, the respondent state exceeds the limits of its margin of appreciation and failed to fulfill its positive obligation in this regard. And of course, the court concludes at the violation of Article 8 of the Convention. It also admitted the applicant's argument that having refused to consider the individual applicant's claims, the domestic courts did not examine the substance of the association complaints. And in this regard, it is interesting, it emphasizing that an association capacity to act on behalf of its members should not be subject to a separate requirement to establish that the people on whose behalf the case has been brought before the court could themselves have met the conditions for being granted by the court's victim status. This is the case. Now, I just have to say that in the absence of a claim for damages, just cost and expenses, the court did not award any sum of this regard, of course. Contrary to other judgments, and despite the importance and urgency of the measures to be taken by Switzerland, the court, following the state's submissions, did not order any general or special measures, but it simply mentioned the declaratory nature of the judgments, the complexity and nature of the issues at stake, and the differentiated margin of appreciation referred to in the judgment. With the judgment, the European Court of Human Rights reshaped in a remarkable way the legal landscape by admitting the nexus between the positive obligation of states in accordance with European Convention and human rights in their obligations to adopt mitigation and other measures against the climate change impact. First, through the interpretative method, considering the concession the convention as a living instrument, the court is maybe, or even in the European level, the first tribunal, international tribunal, to have used a lot this living instrument interpretation method. The court proceeded in its legislative role. After the right to environment, it has set out to further broaden the scope of the normative content in Article 2 and 8 to include a new aspect of protection for individuals and associations with corresponding obligations from the state's parties in the area of fighting threats due to climate change. Second, although litigation attempts were present in different countries, it is for the first time that the High European Judiciary Organ of the Council of Europe, overcoming the obstacle of actio popularis by imposing high-level criteria for individual applicants, had opened a new opportunities for standing of plaintiff organizations both before national and international tribunals. The whole normative environment possesses now a solid spine that will inevitably penetrate the national sphere and transform the internal system of states in this respect. Now, in the title of my topic, of my intervention, Gemma put rightly, and beyond. In the beginning, she had put what after, after. But I said, okay, you put the case, and we speak about beyond afterwards. Now it's time to speak about what happened after the judgment. After an initial angry reaction by Switzerland from all levels of political authorities, by October, it was in April, if my memory is correct, it was in April that the judgment was delivered. By October 2024 came the moment of the opening of the next act of the drama, that of the supervision by the Committee of Ministers of the execution of the judgment. And in this drama, it is important to know that there is a great participation by civil community and NGOs and other interlocutors, for example, UN reporting on human rights and climate and so, and of course, the internal Human Rights Committee in Switzerland. So all these people are, they are not present, I suppose, but they sent, of course, their comments. And so it's not just a discussion between the party and the Committee of Ministers or the delegates. So, as I said, in this phase, apart the absence of more robust and precise legislative and administrative efforts, the central point of disagreement was, and still is, the fair quantification of the responding states' contribution to the global efforts. The Swiss authorities arguing that the national margin of appreciation allows different alternative means to attain the final obligatory target of 1.50 degrees Celsius, and there was no need to adopt a quantified national carbon budget. They said, okay, we have the national efforts, but we are not obliged to give a special quantified budget. Facing the strong reaction of the intervention NGOs, which argued that this failure to adopt a national quantified plan was contrary to the court's judgment, the Committee of Ministers took note of the situation and concluded in its first decision that Switzerland had not yet complied with the judgment. The committee has further examined the case and adopted a second decision last December, a few months ago, 1 month ago, In the meantime, the authorities have presented a national carbon budget. They consented. They said, okay, here is a carbon budget, but there is still disagreement on the burden sharing methodology and the fairness of the Swiss emission target. The NGOs, the UN Special Rapporteur, the Swiss Human Rights Institution invoke that Switzerland has still not complied with the judgment of the court. To their opinion, the carbon budget is fixed according to consideration of their own climate tragedy, which does not represent Switzerland's fair share of global efforts for limiting global warming. To their opinion, the methodology would be contrary to the principles of common but differentiating responsibilities, as well as intergenerational equity. And what happens now? In its decision, the committee first declared its satisfaction with the legislative and other mortgage mitigation and adaptation measures adopted in the meantime by Switzerland, and without going as far as inviting the states to amend the national carbon budget in accordance with those principles, it invites them to do what? To establish an independent national committee. An independent national body suited to the national political structure, drawing on existing good practices from other member states. There is one in France and somewhere else, I suppose, to monitor its climate policy with the mandate inter alia to issue recommendations to the climate authorities. And it also invites them to give some more information about what's happening with the standing of the merit concerning the access of the NGOs before the national courts. Now, and those are my last words, the difficulties met during the stage of the execution of the judgment and the diplomatic decision adopted by the Committee of Ministers shows the limits of the litigation system of Strasbourg, which submits the judicial decision to the political considerations of the minister. On the other side, it is very difficult when we speak about this area in between two, where the state is supposed to have free appreciation of its jurisdiction, to press the state to abide by the court decision. Nevertheless, in this effort, the presence and perseverance of the civil society, as we said before, and other international interlocutors appears to be of great significance in reshaping ideas and in parallel exercising pressure towards a full implementation of the court's decisions. Thank you very much. I'm sorry to have taken more time.
No problem. Thank you very much to Haritini Dipla for having introduced to us this very, very important decision, Klimaseniorinnen versus Switzerland, which is interesting for many, many issues, as she told. First of all, for the issue of locus standi, you know, the having accepted this group, this association, and not singularly each of them. For the Swiss argument of the so-called political question, Switzerland tried to oppose the possibility of having a decision on it. The argument of a drop in the ocean. We are little. We are the Switzerland. How far can we jeopardize climate change? But it is not an argument, of course, as the court said. And the balance showed by the court in using the margin of appreciation doctrine in a right way, and the convention as a living instrument. All this, I think, is a very, very good example to follow. I remind to you that we are speaking not of on advisory opinion, but on a contentious case, of course, and I think it will be a sort of milestone for the future. Thank you also for the follow-up you mentioned about what is happening in Switzerland, in particular with this internal committee on human rights. We in Italy, we still do not have an internal committee on human rights. Maybe better in these times anyway. But I really hope that we will have one in the future. Okay, now we have the pleasure to have with us finally, because it's rain after some delay, arrived, Salvatore Capasso, Director of Department of Human Social Sciences, Cultural Heritage of CNR. Sorry, the floor is yours.
Thank you very much.
Polacco, che so pure.
Good afternoon to everyone. First of all, I would like to apologize for my late arrival. The train completely broke, so I had to change train, and it took me 2 hours to reach Rome from Naples. I know this is not an excuse, but at least I can tell you that it is the cause and why I came so late. But I wanted very much to be here to welcome you in Rome at CNR, and I would like to thank the Institute for International Legal Studies, Gianfranco, for having organized this very interesting conference on a very important issue. Actually, with the GEMA, we have been involved in a big research project here where the CNR has been leading, which is the National Future Center, Biological Future Center, for our recovery plan in Italy. I'm not a scholar, a legal scholar, so what I'm going to say is something that the simple man in the street can say, but still I would like to say something on the issue you are discussing and you will discuss. Climate change, we all, at international level, we think that it's a volunteering stuff, and it's becoming even more and more important to understand that legal entities must be enforcing how government should move to change things. Climate change is something extremely relevant, not because we need to save the planet will survive to our species and the species are living with us, but because we can save ourselves. And of course, the species are living with us today. And also because climate change will be important, especially for countries like us, like Italy or other European countries, because this is something we should tell people, because climate change will help us to implement new technologies, new way of production that will help our economies, will help our people. And this is, I think, a different way of putting things. Otherwise, like Switzerland, people see this kind of objective too much. Law, I said I'm not a scholar, so a legal scholar. Law, but I think law is always engineering is thought as something to rule how people live today. Instead, in this kind of field, we are going to affect how people will live tomorrow, so in the future. So it's a different kind of objective, and it needs fantasy. I know that legal scholar will see this as a difficult stuff, but I think more than in other subjects, I think international studies legal international studies need more fantasy to develop a new way of structuring how our society should be designed to better face some challenges. And here at CNR, we believe very much. So this room, you will see how science has developed for ancient Greece up until today. You see Marconi here, but at the center of everything, there are the four water, air, earth, and fire. There is how we see our planet and our environment. So the environment law here is at the center because we believe that research should be an instrument to help to live better, but also to improve how we live in this planet. So thank you again to Gemma for having, and the organizer for having organized this nice conference. And again, apologies for being late. I think now you do not, still you do not have the lunch, but I think you need to go on with the discussion. So I do not feel guilty because I put myself between you and lunch. So you still have a long discussion to go on. Thank you very much anyway.
Thank you very much to Professor Salvatore Capasso for his intervention, which has been not only a greeting, but also some interesting remark on the specific issue of our meeting, and thank you in particular for his constant support for our activities as international lawyers inside the National Research Council of Italy. So we have now a Q&A session, which will necessarily be very, very short, but nevertheless, if there are some questions, I'm sure, or intervention, I'm sure it will be very, very interesting for the general debate, and in particular that all the participants, all the speakers will be delighted to answer if there are some answers. So, yes, please.
Thank you to all the panelists for such an engaging discussion, also to Professor Androne for having organized this very interesting event. I would like to take advantage of the registrar being here, of course, always in his personal capacity, or at least by doing some sort of dédoublement fonctionnel, by asking him about some insights of the proceedings, but it is a comment that could be also generally directed to all the panelists. Professor Cataldi highlighted the importance of civil society in these proceedings behind the request and for implementation, but civil society and non-governmental organizations are still very much underrepresented in the advisory proceedings, both before the ICJ and the ITLOS. We know that according to the rule of procedure, they can submit some written contributions spontaneously, but they're not acquired to the formal proceedings. Since the advisory proceedings are increasingly dealing with collective interests that are of common concern of humankind, would you think that opening up the advisory proceedings to a formal participation by non-governmental organization would be a welcome development in the advisory proceedings of both the ICJ and the ITLOS?
Thank you. Of course, I cannot provide you with inside information. That would be contrary to my duty. But I may perhaps express some personal views. You mentioned under the rules there is a possibility for NGOs to submit briefs. Actually, it's not under the rules. There is no provision under the rules, but it's true in the practice direction there is the reference is made to unsolicited, in a sense. That means NGOs briefs, and the fact that it's communicated to the members of the court and it's available in a room in the Peace Palace or electronically. At ITLOS, there is a bit more publicity given to those NGOs briefs since they are put on the website. Now, whether it's a good idea, it's something really to be looked after cautiously. There is a risk of opening the floodgates. It means you can receive thousands of pages. For the advisory opinion on climate change, it's good to attract interest. And you know, the court is an interstate court according to its statute. But that means more or less 6,000 pages without annexes. Because with the volume, we are preparing the publication of the volume that will be 10 volumes of pleadings, and probably in the future we will consider simply putting those annexes and those documents on an electronic platform. This, if there are other participants, that will increase a lot. And when you refer to NGOs, you have different categories of NGOs also. Especially in terms of environmental matters. If you look at the NGOs, for example, listed at the International Seabed Authority, you have Greenpeace, but you have also the Friends of Oil Industry. You have a number of, you need to keep that in mind, I would say, just to be brief. It's not just an issue on which you may provide an answer so easily. But, thank you.
Professor Gautier has perfectly explained the framework within the courts and the tribunal for NGOs. I must tell you that in practical terms, during the proceedings of Advisory Opinion 31, NGOs gave an important contribution. For example, UICN was presented a very extensive memorial at the written phase, but also it participated to the hearings in again, an extensive way, and other NGOs restricted themselves to the written phase, but it was very free choices, and they were heard in the same hearings than state parties, than international organizations, without any, let's say, distinction. So they could play an important role. I know that before the Inter-American Court of Human Rights, I know personally because some of my students, former students, created an NGO who was heard in the Bahamas, Bermudas, something there. They told me that they sent me pictures of their hearings, so they were, the NGOs were involved in a more intensive way, but the procedures are completely different than those of courts, tribunals, which are not human rights tribunals. So the position, the role is a little bit different. Thank you. European Court, of course.
Thank you. And I would like just to add, for IUCN, they also participate in proceedings before the court at the same level. They are listed, for example, for International Seabed Authority, they are listed not under the category of NGOs, but intergovernmental. But their status is a bit, it's quite interesting. That could generate another discussion. Thank you.
Any other question? 1, 2, 3. Prego, c'era prima lei.
My question is for all the panelists, and thank you very much for your brilliant presentation. I have a question concerning the principle of common but differentiated responsibilities. And the question is, according to the use that the different courts do with the principle, would you say that they're pushing its status in a certain direction or not? Because like the ICJ uses the principle very much, but also the tribunal. So I was wondering whether they're kind of consolidating it in a certain direction. Thank you.
Well, concerning the tribunal, we must consider that the principle of common but differentiated capability, responsibilities, and capabilities is unknown. We don't have any norm within the convention describing this principle. So the tribunal had followed the line not to create rule. It's not our role to create a rule, and we could have created a new rule by mixing up the existing rule, picking them from one part to another one. So we strictly interpreted what we are allowed to interpret the convention. So we concluded that the reference to capabilities in consideration other capabilities in consideration with their means refer to state, a sentence that can be found in various articles in part 12 and also in articles concerning assistance to less developing states, was based on the same ideas, has something in common. If I remember well, the terms in use are something in common with common but differentiated responsibilities, but it's not the same thing. This principle cannot be inserted in UNCLOS. There is something else in UNCLOS which is different but similar. And so we interpret this different but similar concept.
Okay. Next, yes?
Yeah, it's a bit a question for Mr. Gautier. So the ICJ had a particular paragraph in the advisory opinion which stated that a state can be held responsible for failing to prevent the climate system caused by climate harm caused by fossil fuels actions, including the exploration, licensing, issuing licenses, production, etc. And we have just had, so my question goes at the possible already contradictions that we are seeing developing in case law. And so the recent case of Greenpeace versus Norway is a striking example of precisely that, because no matter how much NGOs have said it's a triumph, in fact, the European Court said just the opposite when it came to issuing licenses. Basically, it was not a breach, and it was not. So I was just wondering, any reaction in your personal capacity as to how this may be resolved? I mean, we have a World Court stating specific examples, and then a regional court that came up, I would say, with a very peculiar assessment of what may be a breach of this particular rule. So any reactions there?
Well, I think after that I will ask Professor Dipla too. But with respect to acts from private actors, of course there is no issue of attributions, it's acts of private individuals. What we are looking at is really the act or inaction of the state. And I mean, when you consider a duty of prevention, to prevent harm, the first time it appeared is, for example, the trail smelter arbitration, which is the act of a private company in British Columbia. Therefore, you have already there a link. A state may be held liable or responsible if the state itself has not taken the necessary means. Of course, if there is licensing or there are acts under its jurisdiction, on its territory, which may contribute to the increase in the emission of greenhouse gas, the state needs to take action. I don't see a real contradiction. It depends which norms you are applicable, you are applying, but here it's for me quite straight. The way the action of a state may be considered as a breach of international obligation for its own conduct, but vis-à-vis individuals on its territory or under its control. But I think you may...
Thank you very much. Okay, there are two things. The first is about Klimaseniorinnen case. Yes, the first one is about Klimaseniorinnen case. This was an argument, of course, by Switzerland, saying that it is not possible to evaluate how to quantify this common but differentiated. It's very difficult, and that's why the Swiss was supporting that to do a quantification of the efforts. This would be done according to the state, but the court spoke, of course, of this principle. And the court gave us an example, the European legislation on climate, where it would seem there are examples of the way how to quantify this. Now this is about Klimaseniorinnen. About the more recent case of Greenpeace, it was a very different case because in the Klimaseniorinnen, it was the substance of the obligations that were in question. In the second case, it was the procedural obligation of conducting, and when exactly conducting, an environmental impact assessment. And there, the court, of course, after having consulted the general framework in Norway, it would seem that it is very precisely mentioned what are the obligations of the country when how an environmental impact assessment should be done and all these things. Then it said that there was no violation. Of course, the applicants were not pleased with that. But then the court mentioned the other courts also. It mentioned also an opinion by the ECtHR court. It looked at the European legislation. So it was surprising, because I would say that maybe because Norway is drills and drills and drills. And it could be seen that the grade of the combustion, the exploitation gas is very important for this country. But the court had to compare the legislations. This is the answer I would like to give you about your question.
I think there is a last question.
Thank you so much for your presentation. I know it's late, but I still have two questions. First is the current status of due diligence, because I noticed in the ITLOS Advisory opinion, I remember it's in paragraph 238, it mentioned that it also contains some sort of goal to reach a result, but there seems to be some hesitation according to the declaration by Judge Jesus. So I'm curious about its current status, and also in the ICJ advisory opinion, it seems to be still an obligation of conduct. So I'm curious about this current status of it. And my second question is that I noticed in the ICJ advisory opinion, it has a mention of intergenerational equity, that we need to see to the future and to protect our environment for the future generations. But considering that the climate change has a cumulative effect, and I think that's the most tricky question compared with other transboundary harm. So it has a very long history of the climate change. So should we also consider like the historical responsibility? But I know that when we consider this historical responsibility, it has perhaps a retroactive effect of laws that we should avoid. So I'm wondering, how should we like face this historical responsibility? So these are my two questions. Thank you.
Thank you.
I will start from the opinion of Judge Jesus. This is a personal opinion by a judge. The advisory opinion was adopted at the unanimity, and therefore the concept, the interpretation of obligations of conduct and the connection between obligations of conduct and due diligence is that contained in the advisory opinion, which I repeat, was adopted at the unanimity. So if we read, for example, Article 194, it is written in that way: states shall adopt all necessary means to protect, preserve the marine environment, and so on. So this is a very peculiar terminology, structure of the norm. It's not a norm which simply say, take the necessary measure, or shall protect the environment. It has an indication of a final scope, a final goal, sorry. Therefore, because of these wordings, some few states sustain that it was an obligation of result, because the result is indicated in the norm itself. So the tribunal said that we can have that this is an obligation of conduct, but the wordings indicate what the final aim of the necessary measures to be taken. This doesn't mean that we are facing an obligation of conduct or of result. We are facing an obligation of conduct, but the norm is written in a way that it indicates these necessary means are necessary for what? For the protection, preservation of the marine environment. It's a kind of obligation of conduct where not only the conducts themselves are indicated, but also the final aim of these conducts. No tertium genus, just an obligation of conduct where the final goal is shaped in the norm itself. This is the way how the third conference on the law of the sea wrote down some articles the ITLOS examined to answer to the request.
Yes, on due diligence, I think we could spend some time. Regarding the notion itself, is it a standalone obligation? That's a question. Because when you look at the no harm principle, the duty to prevent significant harm, it should be applied with due diligence. It qualifies the obligation. It's a standard for the implementation of the obligation. That's a way of looking at it. And therefore, it could be seen as an obligation of conduct in a sense. It colors the obligation. But as the court stated, there is no clear-cut limit. For example, the nationally determined contribution. That's an obligation of result in a sense, because you need to adopt, you need to adapt, you need to implement. But the content, it depends on your capabilities also. The content is probably more an obligation of conduct. It's not so clear to identify the components. There are sometimes different components within one single obligation. That's my view. Concerning the intergenerational equity, as equity, those two principles were considered by the court as principles which would be applicable, but I don't think the court drew any practical conclusion at that stage. It listed the applicable law. You need to bring a claim to see what would be really the effect. That being said, your question was more about the historical side of the emission. There, you enter into not uncharted waters, but there are difficult issues relating thereto. For example, to calculate the countries concerned and the level of emissions, that's scientifically probably possible, but at what time there would be a need for an obligation to prevent harm? At what time did this obligation start? Because emission in itself, an emission of greenhouse gas by itself, is not necessarily unlawful. Depends when, it depends which level. Thus you need to enter into a case-by-case analysis. And that was not the approach taken by the court. But I'm sure if there would be some litigation later, that's an issue which will be raised. But it raises the issue of intertemporal law. At what time a conduct which at the beginning was considered as licit, has become subject to at least the obligation to prevent significant harm. That's a question which has to be studied carefully.
So thank you very much. I hope that climate change will give us the time to see which will be the developments of all this work of domestic as well as international tribunals. I think that our panelists made an excellent work, and so thank you to them, thank you to the audience. And now there is a lunch downstairs, okay? And 2:30 about, there will be the second session here. Can we leave our things here? The stuff can be left here. And so thank you very much to all of you, and see you 2:30.